Chapter 3. Forks in the Law. Rule vs. Counter rule issues. Although your professors don't talk about them in these terms, they've been teaching you about forks in the law since your first day of law school. Indeed, two kinds of forks in the law are so common in legal argument that you can expect to encounter them on virtually every law exam you ever take. One kind of fork presents a choice between rule and counter rule. This is neatly illustrated by our artistepatron hypothetical, where the dispute in question would be resolved one way by the common law rule, which would permit patron to revoke his offer at any time before artiste actually completes the portrait, and another way by 45 of the second restatement, which protects artiste against revocation once she begins her performance. A second kind of fork in the law presents a choice between competing interpretations of a single rule. For the classic illustration of a fork like this, consider once again the treatment of tricycles under a rule that prohibits vehicles in the park. There, the question might be resolved one way by an interpretation that focused on the language of the rule, tricycles are vehicles, and therefore forbidden, and another way under an interpretation that focused on the rule's apparent purpose. Tricycles just don't pose the kinds of dangers in public parks that automobiles do. In this chapter, we are going to focus on issues that present the first kind of fork. We'll call them rule vs. counter rule issues. We'll start by offering a map of the patterns in which issues of this sort appear, and then we'll explore some of the reasons that students don't recognize them as issues when they encounter them on an exam. A. Patterns to watch for. For many lawyers, the dream client would be the one who walks into your office and presents you with a problem that can be resolved in her favor simply by citing a legal rule. The court must rule for my client, you imagine yourself solemnly declaring, because Rule X says so, after which you close the case file and collect your fee on the way out the courthouse door for a golf date. If you've been in law school long enough to be reading this book, chances are you've already figured out that it doesn't work that way very often in the real world. One reason for this, and a reason that often comes as a surprise to students who find the prospect of learning just one rule for every situation challenging enough, is that it is frequently the case that the lawyer for the other side can respond to the rule you cite with a different rule, and under that rule his client rather than yours will prevail. It's bad enough that your dreams of an easy win and a golf date are shattered. What's far worse, at least from the perspective of most law students, is that this means that there are twice as many rules to learn. Yet the bad news comes with a silver lining, for the way most law professors test this multiplicity of rules is pretty straightforward. They will give you a hypothetical that would be resolved in one way by Rule X and in another way by Rule Y, and chances are that the difference between the rule and the counter rule will have been analyzed in some depth in the course of class discussion. Indeed, in American law, these rule vs. counter rule relationships appear in patterns, and here are some of the patterns you are most likely to encounter on your exams. 1. Traditional rule vs. modern rule. In most of the subjects you'll study, a major theme is that law changes over time. As a result, you'll find yourself studying topic after topic in which you'll learn first about the traditional rule and then about the modern rule governing this or that particular problem. An excellent illustration is our artistepatron hypothetical. VV here, the traditional rule, a product of the common law, would permit patron to revoke his offer at any time before artiste completes the portrait, and the modern rule, established by the second restatement, would prohibit revocation once she begins the requested work. No doubt you can readily think of additional examples of such traditional vs. modern rule relationships. Consider the following hypothetical, which raises a rule vs. counter rule issue familiar to anyone who has taken torts. The moment the light changes, penny pedestrian steps into the crosswalk without looking both ways. Meanwhile, Danny Driver, who just left his favorite tavern after downing 3 gin and tonics in the course of an hour, is driving his car at a speed well in excess of the posted limit and weaving wildly through traffic. As pedestrian sets foot into the street, Driver races into the intersection from behind her and makes a sharp turn directly into her path, striking her and causing her serious bodily injury. What rights does pedestrian have against driver? Do you see the issue? Everything turns on whether we apply the doctrine of contributory negligence, the traditional rule, or the doctrine of comparative negligence, the modern rule. Thus, drivers' conduct drinking and driving and speeding and weaving and making sharp turns is clearly negligent reckless. Even but pedestrians' failure to look both ways before stepping into the intersection is probably negligence on her part as well. Under the doctrine of contributory negligence, pedestrian's own lack of due care is a complete bar to her cause of action against driver. By contrast, under the doctrine of comparative negligence, pedestrian would be permitted to recover that portion of her damages attributable to driver's negligence rather than her own. Thus, if on these facts we consider driver say 90% at fault and pedestrian 10% at fault, pedestrian can recover 90% of the damages from injuries resulting from the accident. Thus, once again, we encounter an issue that is a consequence of rule and counter-rule leading to contrasting results. 2. Different strokes for different folks. A second pattern to watch for occurs when different jurisdictions adopt different rules because of political, philosophical, or regional differences between the jurisdictions in question. If enough states have adopted a particular approach, your casebook and/or your professor is H. Kelly to describe it as the majority rule, and to refer to the less popular approach as either the minority rule or even the X rule, where X equals the name of some state that takes the nonconforming approach. When we were in law school, for example, there seemed to be a special Massachusetts rule for just about every topic. In other contexts, however, you will learn that no rule has commanded a majority. But regardless of the particulars, the point is that when the law on a topic is split in this way, you should watch out for a rule vs. counter-rule issue on your exam. Consider the following problem, which is drawn from the riparian rights section of the typical property course. For over a decade, Yasker has diverted water from the stream, running through his land to run a generator providing electricity for his family farm. Bo purchases the land just upstream of Yasker and diverts a small portion of the stream to water his flock of sheep. Because of the diminution in flow, the stream no longer has the force to power Yasker's generator. What rights does Yasker have against Bo? As in the other cases we've looked at so far, the issue presented here once again involves rule and counter-rule. But this time, the conflict is not between traditional and modern rules, but rather between contemporary rules embraced by different jurisdictions. Thus, under the riparian rights doctrine favored by many Western states, the rule of prior appropriation, Yasker may well have a claim against Bo for the diminution in flow, since Yasker's rights to his usage of the stream predated Bo's by many years. But under the rule of reasonable use, which is applied in many Eastern jurisdictions, Bo is entitled to her fair share of the stream, no matter how much longer Yasker has owned the adjacent lot. As long as Bo's use is a reasonable one, as watering sheep from a stream running through farm country would seem to be the fact that it deprives Yasker of the flow to which he'd grown accustomed is irrelevant. Other familiar instances of such different strokes issues abound. Consider, for example, a variation on the driver-pedestrian hypothetical we examined a few moments ago. Assume that pedestrian's husband Harry looked on helplessly and in utter horror as pedestrian was struck by driver's recklessly driven car, but that Harry managed to avoid contact with the errant vehicle himself. While driver's conduct was clearly the cause of severe emotional distress on the part of Harry, Harry's rights against driver may turn on another, different strokes issue. Some states require a physical impact before permitting a plaintiff to pursue a claim for emotional distress, in which case Harry would lose for want of such impact, while other states permit plaintiffs to pursue a claim without such impact, in which case Harry may well be able to succeed in his claim. 3. Common law vs. statute. Let's end this section with one more variation on rule vs. counter-rule issues. In each of the hypothetical discussed thus far, the issue arises in the context of a conflict between two rules that each has its basis in the common law. But in your coursework as well as on your exams, you will also encounter issues that arise because of a difference between a common law rule and a statutory rule. Indeed, as state legislatures enact more and more statutes regulating matters historically governed by the common law, you are likely to confront this kind of issue on your exams with increasing frequency. Consider then the following illustration. Billy buyer mails Sally seller a purchase order for 1,000 of seller's widgets, offering to pay her advertised price of $2 per widget on delivery and requesting immediate shipment. Seller replies by sending buyer an acknowledgement of order, promising to ship 1,000 widgets immediately and agreeing to the price and payment terms. Seller's acknowledgement also states that seller expressly disclaims any warranties with respect to any items shipped pursuant to this acknowledgement. After buyer receives seller's acknowledgement, but before seller ships the goods, buyer telephones seller and states that he is backing out of the deal. What rights, if any, does seller have against buyer? Do you recognize the issue from your contracts course? On the one hand, under the common law mirror image rule, the terms of a would-be acceptance must mirror the terms of the offer in every respect. Although seller's acknowledgement accurately recapitulates the description of goods, quantity, price, delivery, and payment terms stated in buyer's purchase order, it breaks the mirror by adding a term, i.e., the disclaimer of warranties. As a result, the acknowledgement is not an acceptance of the offer, and there is no contract that would preclude buyer from backing out. On the other hand, under the pertinent statutory provision UCC 207, an otherwise valid acceptance forms a binding contract in spite of the fact that it purports to add terms not found in the offer. And if the statutory rule were applied in this case, the seller's acknowledgement would operate as an acceptance of buyer's offer, thus binding buyer to the contract and preventing him from backing out. B. How professors test rule vs. counter rule issues and why students frequently miss them. As the foregoing examples suggest, rule vs. counter rule issues are pretty straightforward. As long as you're familiar with the particular rule vs. counter rule relationship in question, you aren't likely to miss it when it appears on an exam. Yet law professors find that even students who have studied hard and prepared well, miss these issues with surprising frequency. Our view is that the principal reason for student error is not that students fail to see the rule vs. counter rule situation, but that they don't understand that when they've seen one, what they've seen is an issue. In our experience, many students ignore the rule vs. counter rule situations they encounter because they figure that, at the end of the day, only one rule will govern the case at hand, and their job is to figure out which rule it is and B, to apply that rule to the facts presented. Their thinking goes something like this. Hey, I know this one. There's some old rule that lets the offer revoke even if you're halfway up the flagpole, and there's a restatement section that fixes all that. So who cares about the old way? The professor asked us to discuss the rights of the parties, and that must mean under the law that would apply today. Now where's my copy of the restatement? Truth be told, these students may be on to something. Sometimes the professor has in fact constructed the question in such a way that the student will be right if he appes say the restatement and wrong if he applies the common law rule. But here's an important test-taking tip. If the professor went to the trouble of teaching you about the difference between the restatement and common law rules governing the revocation of offers, and if she also went to the trouble of designing a problem that would come out one way under one rule and another way under the other, chances are pretty good that she expects you to recognize this difference and is ready to award issue spotting points to the students who do. And while it's true that no self-respecting lawyer would pay much attention to the old rule in a setting in which the restatement alternative obviously governed, it's equally true that no self-respecting law student should pass up the chance to earn additional exam points so easily. But if you are attempting to answer a question in which the choice between rule and counter rule seems to be that straightforward, you ought to take this as a signal that you may be missing something in your analysis of the problem. Since lawyers can only fantasize about the dream client whose case can be resolved by the straightforward application of a single legal rule, law professors rarely give exam questions that are this simple either. Indeed, at least 9 times out of 10, the professor will try to construct a hypothetical in which the choice between rule and counter-rule is not nearly so clear-cut. Fortunately, such hypotheticals tend to appear in patterns too. And fortunately for those of you with the good judgment to be reading this book, we're going to help you learn to spot them. Watch for the unidentified or imaginary jurisdiction. One common way that professors test rule vs. counter-rule issues is to set the facts of an exam question in an unidentified or even imaginary jurisdiction, e.g., Pleasantville or Remilak or the state of Ames. When you encounter a rule vs. counter-rule issue in this setting, you can be sure that the professor is expecting you to analyze the facts at hand under both the rule and the counter-rule, since the choice between the competing rules is obviously up for grabs. Watch for the jurisdiction whose law wasn't explored in the course. Sometimes you'll encounter an exam question set in a jurisdiction whose law you do know. When that happens, your job is to apply that law and then move on to other issues. If, for example, your torts course examined Florida's approach to comparative negligence in painstaking detail, and on the final you encounter a question involving an accident that occurred in Florida between Florida residents and B is the result of plaintiff's negligence as well as defendants, you'd be making a serious mistake if you saw this question as an opportunity to provide a lengthy rule vs. counter-rule analysis of the difference between comparative and contributory negligence. The professor has taught you Florida comparative negligence and has designed a question specifically asking you to apply that law. It is therefore virtually certain that she wants you to focus like a laser beam on that task. And while you might earn some issue spotting points for offering a sentence or two contrasting the Florida law analysis with the analysis under competing approaches, the professor has emphasized EGZ's contributory negligence. An extended discussion of an approach that obviously doesn't apply to the facts at hand will almost surely be penalized. Indeed, if your discussion suggests that you are hedging your bets because you don't know which rule applies in Florida, you may well be on your way to a grade you won't be very happy with. But many law school courses, and especially the classic common law courses like contracts, torts, and property, examine majority vs. minority approaches and traditional vs. modern rules and rarely focus in on the current law of a particular jurisdiction. If you encounter a rule vs. counter-rule issue on an exam in a course taught like this, it's a safe bet that the professor isn't testing to see whether you can guess which rule will apply. Even if she has set the facts of the problem in some specifically identified jurisdiction, e.g. Idaho, she is far more likely to be testing you on what she taught you and trying to see whether you recognize that more than one rule might apply to the facts at hand. Watch for traditional vs. modern rule issues where the modern rule has not been judicially adopted. When students learn about traditional rules and modern common law rules in a particular area of the law, many conclude that they need to know the modern rule, and that the rest is history. I didn't come to law school to learn how to practice in 19th century England, cracked one of our students in this connection. But this attitude can lead to serious mistakes, for the so-called modern rule is frequently only a trend that many jurisdictions have not yet adopted and, for all we know, might never embrace. Indeed, sometimes the modern rule isn't even a bona fide trend, but is merely the approach taken by a handful of cases that have captured the fancy of the members of the American Law Institute and inspired a black-letter formulation in the latest restatement of law. And as we frequently remind our students, the restatement is a beautiful thing, but A, it isn't a statute, and B, it isn't law unless and until a court or some other authoritative body says it is. In the end, then, our advice here is the same as in the previous point. If an exam question places you in jurisdiction X, and your professor has stressed that jurisdiction X has adopted the modern rule on the relevant topic, then that's clearly the rule you should emphasize in your answer. But if you encounter a traditional vs. modern rule issue in virtually any other setting, you would be making a serious mistake to ignore the traditional rule and simply assume that the modern rule has been adopted.